कोई रत्तियां कमीज़ानी लमाना मारे मामा मिठिया में चीज़ानी।
मेरा नाम मुकद्दस है और कोट मेरा घर है और ये मेरे लिए किसी जन्नत से कम नहीं। हमारे भी कुछ ख्वाब हैं जिनकी ताबीर को हमें पाना है।
आइए इन बच्चों के ताबनाक मुस्तकबिल के लिए अपना हिस्सा डालिए। अपनी ज़कात, सदकात, खैरात और इमदाद कोट को दीजिए।
UK number 0300 123 7774. Website court.org.uk.
Almarad Tiles. With over 70 stores nationwide, we are now open in Peterborough. Up to 50% discount offers now on. Largest selection of tiles. Full bathroom suites from only £189. Paint, LED lighting, laminate flooring from only £7.99. Over 1,000 designs of wallpaper in stock. We have everything you need. Come and visit us at 193 Fengate, Peterborough, PE1 5BH, or call us on 01733 34 58 47. Almarad Tiles, now open.
In the mood for some authentic Desi food? Try Desi Restaurant on Lincoln Road. Start your day right with our Desi breakfast. Every day from 7 a.m. to 1 p.m. Halva puri, channa, nihari, paya, paratha and omelette. Need a tasty lunch? Every day 1 to 4 p.m. we've got fast food, pizzas, kebab sandwiches, tandoori dishes, balti dishes, biryanis and much more. We're also open every evening 5 p.m. to 1 a.m. Try our Desi Tawa special or our fresh handi, 1 kg chicken or lamb on the bone, cooked to order. Eat in, take away or free delivery. Visit desirestaurant.co.uk to view the full menu and order online. 60-seat capacity and a private function room. Catering service also available. Desi Restaurant, 298 Lincoln Road, Peterborough, PE1 2ND. Call us now on 555 795.
If you want to learn about Islam and Muslims, stay tuned to Salaam Radio 106.2 FM.
Welcome to the Immigration Hour with Brother Amjad and Sister Severine. We are both experienced immigration practitioners registered with the OISC at level 3, and we've got over 15 years experience. The aim of our show is to offer tips, guidance and general information on the topics covered, but it's not to replace or be taken as definitive legal advice for your individual cases. Tonight, we will give you general advice on spouse visa, which is one of the most common visas that we come across in our daily practice. We will concentrate on applications made outside the UK. We will discuss the requirement of the immigration rules to meet for the visa application to be successful, and we will also give you some practical advice on how to submit an application. We would like the show to be as interactive as possible, so please do not feel shy. If you have a question or if you need clarification, pick up the phone and call us on 01733 602133. You can also text us on WhatsApp on 07745 278978. We are also on Facebook. The show is in English, but we can speak other languages, such as Urdu, Punjabi, Pahari, and French, so please do not hesitate. If you do not speak English very well, we can still take your questions and try to answer. Over the years, the requirement of the immigration rules to meet for an applicant wanting to come to the UK on a spouse visa have evolved, not always in favor of the applicant. We can mention major changes over the years. Most importantly, in 2008, for example, when the Conservative government amended the immigration rules to introduce a new minimum requirement age of 21 that foreign spouses and their sponsors had to meet instead of the previous age of 18 before the foreign spouse could be granted a visa. Although it was designed to force stopped marriages, the Supreme Court ruled that the change in the rule was disproportionate and it was interfering with the right of those who were in a genuine marriage. In November 2011, the government reinstated the age of 18. But you will notice that it took more than 3 years for the government to change its mind. And also it was pushed by lawyers and it had to go to the Supreme Court, which is the highest court in the UK, for the government to capitulate and agree to reinstate the age of 18. Over the last 20 years, there has been an increase of length of time spent in the UK for a spouse before being able to apply for indefinite leave to remain. Some of you will remember, and some of our listeners probably remember coming to the UK in the 90s and being able to have indefinite leave to remain after 1 year. Now it's no longer the case. You have to wait 5 years before being able to be granted indefinite leave to remain, which has been multiplied by 5 over the space of 15 years. Also, there has been an introduction of a mandatory English test, which increased in difficulties. It started with an A1 test, which was quite easy, basic English, and now they introduced a new test when you want to apply for an extension, which is an A2 test, and a B1 test has been introduced when you want to apply for indefinite leave to remain, and naturalization. Some will argue that it's a good thing that the introduction of an English test has taken place. Some people will argue that's not a good thing because a lot of ladies or a lot of gentlemen coming from some countries are uneducated, do not have an education in their own language, and find it extremely difficult to learn a new language. Also, in order to apply for indefinite leave to remain, now you've got another hurdle. You've got the introduction of the Life in the UK test for indefinite leave to remain. Again, very difficult for people who are uneducated. You've got people who have not studied in their country of origin, and some of them will be quite baffled by the questions asked in the Life in the UK test. For example, how many wives Henry VIII had. I'm not sure that someone coming from Kazakhstan or Pakistan or even some African countries will be fully aware of how many wives Henry VIII had. But that's the situation, that's the framework we are working into at the moment. And to add to that, in July 2012, there has been a major change, which is the introduction of the minimal annual income requirement of $18,600 for the sponsor to meet if he wants to sponsor his wife or husband into the UK. So as you can see, all those measures make it very difficult and stressful for applicants and their family. Adding to the more stringent requirements the applicants and their sponsors are facing, they also have to meet very high application costs. Some of the application costs have been multiplied by 10. Delay in decision-making in some countries. In some countries, they will tell you that you will get a decision within 90 days, but in fact, you have to wait 120 days or even more. Delay by the first-tier tribunal in listing cases for hearings. It can take more than 18 months in some cases to have a final decision on an application. So in this hostile atmosphere environment, how can we still make a successful application for a spouse visa? So we're going to ask Brother Amjad to take us through the process. And first of all, we will talk about the requirement of the immigration rules.
Thank you very much, Severine. I think you've given a very detailed introduction about spouses. I don't know what I'm going to say and what I'm going to add to it.
There's plenty to add, I'm sure.
Anyway, thank you, Severine. Yes, spouses from abroad, there are 3 major requirements that you need to satisfy. Suitability, financial requirement, relationship requirement, and English requirement. I think what we do is we'll go through each requirement. I mean, if you want to ask the questions, and I will
yes.
respond. So those are the 4 headings that we will be talking about.
That's correct. Just for our listeners, we will be talking today only about entry clearance as a partner, as a spouse. So we are not talking about application in country. We are talking about application out country. We will be also talking about the easiest and the simplest applications. People who have complex financial situation, we won't be dealing with that because it's complex, and then they should seek legal advice. Can anyone apply for a spouse visa, or is there any suitability requirements?
Yes, there are suitability requirements. For example, criminality, failure to comply with the Home Office when they've been in the UK, they've not paid the NHS, they've made false representations, they had litigation costs that were owed. But these sort of criminal suitability requirements apply to the people who've been into the UK. So majority of the cases that we do from abroad, the suitability requirement will not be applicable to them. It's only to those people who've entered the UK. So for example, they came to the UK as a visitor, they came to the UK as a student, they became overstayers, they've been utilising the health service here, they failed to pay the NHS costs, and when they want to reapply and join their spouses in the UK, they will be affected by the suitability requirement.
Yes, that's correct. Exactly. It's for people who have already been in the UK. So what's the definition of partner? In the past, the terminology of spouse was used, but now partner is used. What does it mean?
Well, it's a spouse, civil partner, fiancé or proposed civil partner, or person you have been living together in a relationship akin to marriage for 2 years. Those are the definitions for a partner.
So does it apply also to same-sex relationship?
Yes, I mean, a civil partner could always make an application, yeah.
What status does the sponsor need in order for him to sponsor his spouse to come to the UK?
He needs to be a British citizen. He needs to have a settled status in the UK. He must be a refugee on a humanitarian protection grounds. He needs to have a status on those bases.
So just to be clear, a sponsor who has limited leave to remain in any other categories, would he be able to bring his spouse to the UK under the Appendix FM, obviously?
No, limited leave to remain, no. You cannot bring your spouse over.
Yeah, obviously there is some different immigration rules for people on the PBS or on the tier system, but we're not
dealing with that. Yeah, that's correct. That's correct.
So can you marry someone who has not reached the age of 18?
Well, you can marry someone who's not reached the age of 18. However, you cannot make an application till that person doesn't reach the age of 18. So at the date of the application, the applicant needs to be 18.
Yes, that's correct. And with regards to the marriage of someone who is under the age of 18, it depends, obviously, of the laws of the country.
Of the country, yeah.
Can the proposed spouse be related to the sponsor?
There's a set definition. Close family relations are not acceptable. Extended family members, that's acceptable. Like nephew, nieces, sisters, brothers, they are prohibited. They can't get married. Yeah,
that's correct, yes. Is a telephone marriage acceptable?
Telephone marriage will be classified as a proxy marriage. Proxy marriage is not acceptable. There are certain countries, for example, if I'm correct, it's Ghana and Brazil, where they appoint a proxy, which marriages are acceptable. Again, there needs to be an agreement between UK government and that particular country for a proxy marriage to be a valid marriage.
Yes. Can a sponsor who has no intention of living with the spouse support an application for his spouse to come to the UK?
No, they can't. You need to have an intention of living together on a permanent basis. You need to be supportive. During that process, if that is withdrawn, then they shouldn't be supporting the application.
Yes, it wouldn't be a genuine
relationship. That's correct.
How to prove that the relationship is genuine and subsisting? It's very difficult, isn't it? It's very subjective.
It is. On the relationship requirement, I say there are 2 limbs to it. One is that you have a genuine subsisting relationship. And second is that you have an intention of living together on a permanent basis. To make the marriage valid, a marriage certificate is sufficient. that will show that you are married. Now, I think I need to clarify. A lot of people ask this question that, if we are married in our country of origin, that marriage is not recognised in the UK. No, that's wrong. If you get married in your country of origin, and if it's accepted according to your country of origin's law, that marriage is automatically accepted in the UK. So marriage certificate confirms that this marriage is valid. In terms of subsisting, you need to have communication, like for example, remittance slips, you send them money, telephone conversation, WhatsApp conversation. These are sort of factors that make it strong that it's a genuine substantial relationship. Intention of living on a permanent basis. Again, when the sponsor supports the application, that itself shows a clear intention that they are willing to live together on a permanent basis. But even to make it even stronger, I would advise that they do a sort of a declaration where they actually write everything down, that they have a clear intention of living together. And I think it will make it even more stronger if they put on what they intend to do when they come into the UK in terms of family planning, or if they want to buy a property and so on and so forth. All these things, if they add into that sponsor declaration, it will make it stronger.
Yes, that's correct. Just on the validity of the marriage, I had a few cases recently from a particular country, from Pakistan to be precise, where the clients were Christian and another couple was Ahmadi. Just to clarify, Pakistani law does not seem to recognize those marriages, and they are not able to get the standard nikah nama that any other couple would get. However, the church marriage in Pakistan was recognized and has been accepted by the immigration, and the spouse visa was granted, as well as for the Ahmadi couple, the marriage certificate issued by the Ahmadi community in Pakistan was accepted as a valid marriage.
I remember you discussed that with me. Yes, we had a discussion about that.
Two particular cases where in Pakistan, obviously, they can't get married for whatever reason. So.
Okay, if I'd just like to add, I think you've mentioned 9th of July 2012,
that's correct,
when the Appendix FM came into effect. I think this is probably useful. This is from experience where a client came to the UK under the old rules, saved provisions, and he wasn't able to meet the English requirement. He applied for extension under paragraph 284, and he went to court, and his appeal was allowed. And what the Home Office did, rather than giving him an extension under the old rules, they put him on the new route, under the 5-year route. So he came to see me in the office, and I looked at it, and I said, well, when did you come to the UK? He said, well, I got my entry clearance before 9th of July 2012. And I said, when you applied for an extension, under what rules did you apply? And he said, well, I applied, and I looked at the paperwork, and I said, well, the Home Office is wrong. So what I did is, I challenged the Home Office decision. I made an application for indefinitely to remain, on the basis of relying on the transitional arrangement from 9th of July 2012. And what happened? They granted him indefinite to remain. So there may be some people there, or clients there, potential clients, who may not be familiar with this, that if they are under the old rules, they should remain on the old rules. However, if they change them on a different category, they need to look into it, but there may be some room where we can argue that the Home Office made a wrong decision and they've put them on the 5-year route. So if there are any people there, I would advise them to look into that paperwork, have a look at it, and challenge this.
Oh yes, of course, it's very important. And
why I'm saying that, Severine, because there are cost implications.
Yes, of
right?
course.
So they've got indefinite, they've been sorted, but if they're on the 5-year route, they have to apply twice before they could get indefinite to remain, and there are not cost implication and lawyers' fees included as well. So I think they need to look into that. There are any people there, they should look into their paperwork and get that addressed.
So anyone who has been granted a visa before July 2012, and I would even say who has applied for a visa
both.
before
Yes.
July 2012, and who has not been given indefinite leave to remain yet for any reason, please look at your visa, and you probably could apply for indefinite leave to remain.
Yeah.
Okay, but we are talking about the current immigration law. We are talking about the current immigration rules, and we are talking about Appendix FM. So the main element of the July 2012 was the financial requirement. So what are the financial requirements to be met for a sponsor to bring his wife or her husband to the UK?
Right, the financial requirement is 18,600. That's just your spouse. If there's a child involved, the first child, if you want to add a child, it'll be 3,800, and then each additional child will be 2,400. So the basic is 18,600.
Yes, so just to give you example, for a wife alone, it's 18,600, a wife or a husband alone. But as soon as you bring one child, it's 22,400. 2 children, 24,800, and 3 children, 27,200. So it is a huge amount of money. It means that the person needs to have, in fact, quite a decent job. I don't know the average in Peterborough, but many people who will be working in factories or working in takeaways that will earn 27,200. Not many.
Not many. If I'd just like to add on that, a lot of people are doing 2 jobs. They're doing a lot of overtime to meet the threshold.
Yes, it's putting a lot of pressure
on
people.
A lot of pressure.
Yes. So how can the sponsor meet the financial requirements?
By way of employment, self-employment, savings, other form of non-employment such as receiving rents. The popular or the most employment requirement which I've gone through, and I think you'll probably agree with that, is employment and self-employment, which I've dealt in many ways. Yes.
The rest, obviously, savings, it's very difficult. And other form of non-employment, it's rare. We dealt with a few clients, but it's rare. We have to say. So is it enough to have been employed for a couple of months before making the application?
No. The immigration rules say that you need to be employed for 6 months and you need to meet the financial threshold within 6 months. So no, it's not 2-3 months, it's 6 months.
So you need to be employed for 6 months, but can you have several employers within the 6 months?
Yes, I mean, several employees would be quite difficult for them to have several employees, but yes, you could have 2 employees within 6 months, but they need to be in parallel. You can't say that I've been working for one employer, say you start in January, then second employer you start in June. It needs to be parallel in line with the first employment.
Yes, so you can have 2 employers in order to meet the 18,600. However, you need to have been with the same employer, each employer, for at least 6 months before you can make an application.
So in parallel,
Okay, and if I get cash in hand from my employer, what do I do? Can I still bring...
I mean, the whole purpose of this Appendix FM and the financial requirement is that everything is reflected in the bank statement. Everything goes into the bank. It's like a sort of generating income for the banks. So if you get cash in hand, I'm sorry, you won't meet the financial requirement. It needs to reflect in your bank statement.
But if I get cash in hand from my job and I put the exact amount of money, so if I paid, for example, 120,000, sorry, not 120,000, £150 a week, and if I put exactly the £150 a week in my bank account, would it be acceptable?
That would be acceptable, as long as it reflects with your payslip. That's the important point. It needs to reflect with your payslip.
That's correct. So if I haven't been employed by the same employer in the 6-month period, but I've been employed by another employer before that,
then the 12 months will apply. So what you need to accumulate your 12 months income, and then you put that together, and yes, you can make an application on that basis.
Yes, and if you accumulate the 12 months, so the 12 months before the application, you need to meet the 18,600. Yes?
Yeah, that's
so
doable.
Either you've got an employer and you've been employed for 6 months and you are able to justify that with pay slips and bank statements showing the money coming in, or otherwise you rely on 12 months, but 12 months before the application, you need to have met the 18,600.
That's correct.
Okay. Now, if the partner is abroad and if he works, can the work be taken into consideration, the earnings be taken into consideration?
That employment will not be taken into account, no.
Can the couple rely on their savings if they are short of the 18,600?
Yes, there's a formula they need to follow. Say, for example, the sponsor is earning 16,000 and there's a shortfall of about, say, 2,600. That 16,000 is the base, which will be just classed as 0. So then you multiply that by 2.5, and then you add that 16,000, whatever the amount is, that needs to be into your account for 6 months, and then that's acceptable. That's the way to meet the shortfall.
Okay. So we can rely on savings, but there are some rules
Rules
and
that you
some
need to follow.
very difficult rules that we're going to be dealing with in a moment.
Now, if I may add, so, I mean, 16,000, they'll ask where did it come from.
Oh, yeah, definitely.
Right,
You need
okay.
to be able to justify your
the
money.
£16,000, yeah.
Can they rely on a third-party support to help them to meet the 18,600? So, for example, they've got a rich uncle who is willing to help.
I mean, you can only rely on third-party support if your circumstances fall within the exceptional circumstances and where the Home Office would believe that if we don't allow the visa, it'll breach Article 8. Mm-hmm. On those sort of grounds, yes, you can rely on third-party support, but otherwise it'll be difficult.
Okay. Can money received from child tax credit, working tax credit or child benefit be taken into consideration and be part of the 18,600?
No, they can't. No,
they can't,
they
yes.
can't.
Okay, listeners, I hope you are still with us. And if anyone has a question, please don't hesitate. You can call us or you can text us on WhatsApp and on Facebook. Please do not hesitate if you've got any questions. Okay, now, what about self-employment? What income is taken into consideration?
Now, there's a case law on self-employment. It's the last financial year. So, for example, if I was to make an application in March this year, my last financial year is April 2018-19 will be taken into account. You can't take into account what you've done after that. So if I make an application after April 2020, then it will be this April which will be taken into account. So a lot of people get confused. They start working towards the new financial requirement, but technically speaking, they do make an application before April and they fail to realise that it's the last financial year that needs to be taken into account. So you've got to be very careful.
So if I make my application today, which year do I have to submit?
It'll be the last financial year. It'll be last April 19, 20.
2019.
Yeah, that's correct.
All right, okay. Yes, 2018, 2019.
Yeah,
okay.
That's correct.
Can I take, let's say that my business has done well 2 years ago, can I average my earnings?
Yes, you can.
Yeah.
Yes, you can, yeah.
Okay. So how can you evidence self-employment? I know it's very difficult and it's very stressful for people.
I mean, when I get clients who are self-employed and I just start scratching my hair, there's so many documents that you need to provide. So, for example, your annual tax return, your accounts, SA 302, where it shows that you've paid your tax, your business. I mean, if it's a leasehold, then you need a letter from a chartered accountant. And it depends on your income, but again, there's so many requirements that you need to meet compared to if you were employed.
Yes, there is quite a lot of documents, and most importantly, the personal bank statement.
For the 12 months, yeah.
For the 12 months.
That's correct,
I
yeah.
can see that I've got a question on my personal Facebook coming from Abdul from Bedford. And Abdul wants to ask a question that probably is going to interest a lot of our brothers. Mm-hmm. And not that many sisters will be interested. They will be interested by the answer, not by the question, really. So the question from Abdul in Bedford is, can I bring my second wife to the UK? Can I bring my second wife to the UK?
I'm looking at my Facebook as well, and I got a same question from Mohammed Jamil as well. if I could bring my second wife to the UK.
Okay, listeners, you have to stay with us to get this answer. So please, kids, be quiet, because Mom wants to hear the answer of this question. We will see you back soon. Stay with us.
Stay tuned to Salaam Radio after this short ad break.
It doesn't take much to bring some difference. You give some change, which makes a change. Because nothing gets mileage like a charity. Just a little change turns into a chain. And before we know it, the results are massive. So give a little to make a big difference. For donations, call now. UKIM 0207 387 2157.
Had a car accident or an accident at work? Accident specialists are experts in no-win, no-fee accident claims. Leave the hassle to us. Our multilingual settlement experts will manage the entire claims process on your behalf, with nothing to pay up front. We provide services such as credit hire, taxi vehicles, recovery, storage and much more. For full details on our range of services and a free consultation, call us on 01733 555 774 or visit our office at 249 Lincoln Road opposite the NatWest Bank. Accident Specialists. Start your successful claim today.
Do you own a restaurant or takeaway? Cater Fair is an expert supplier of new and used commercial catering equipment. Visit caterfair.co.uk for quality equipment on sale at the lowest prices, or call us on 01733 310 115 or visit us at 11 Royce Road, Fengate, Peterborough.
जब बात हो हलाल मीट की तो कैसे मुमकिन जिक्र न हो हाजी बाबा का। हाजी बाबा हज़दा में आपके लिए। हम हज़दा में अरसा 10 साल से जायद मुल्क भर में 45 से जायद काउंटर्स के साथ बेहतरीन पैकेजेस, हर वैरायटी का मीट और आला मायार के लिए आइए हमारे पास। चिकन ब्रेस्ट, चिकन क्यूब या कीमा सिर्फ 3.99 पाउंड पर केजी, लैम या शीप लेग, लैम शोल्डर और मिक्स सिर्फ 6.99 पाउंड पर केजी, बेबी चिकन सिर्फ 1.99 पाउंड पर केजी। आपकी सहूलत के लिए वक्त की बचत और मायार की जमानत, तमाम हलाल गोश्त और अशिया जरूरत एक ही छत के नीचे। हाजी बाबा हलाल मीट, फाइंड अस इन हज़दा।
Assalamu alaikum, Dr. Shabina here. Has your child had their flu vaccination this year? All primary school-aged children are entitled to the flu vaccine in their schools, helping to protect you and all the family against flu, which can make vulnerable people very ill. Call the school immunisations team on 0300 555 5055 if you'd like your child to get protected.
The first revelation of our Holy Prophet stated, "Read, in the name of your Lord, He who created you." When knowledge is so important, then why are the poor missing out on the basic right? UKIM. Spreading the light of literacy among the orphans and needy children. Let's give these children a brighter future this Ramadan. For donations, call now or visit ukim.org.
بسم الله الرحمن الرحيم ألم تر كيف فعل ربك بأصحاب الفيل ألم يجعل كيدهم في تضليل وأرسل عليهم طيرا أبابيل ترميهم بحجارة من سجيل فجعلهم كعصف مأكول.
Peterborough's community radio station, Salaam Radio, 106.2 FM.
Welcome back to the Immigration Hour with Brother Amjad and Sister Severine. Okay, so I'm sure you want this answer. So the kids are quiet, the cars...
Severine, can you repeat the question, please?
The question is, can I bring my second wife from abroad? Taking into consideration that the first wife is in the UK.
No. Do you want me to be sympathetic to whoever's asking the question? Or do you want me to give them a legal response?
No, we have to give the legal response.
Well, the answer is no.
So, sisters, you've heard.
Yeah, no,
they
you can't bring your second wife into the UK. No,
you can't bring your second wife in the UK. I'm checking my Facebook, and also I've got some people who are asking us about a partner from the EU. Someone who wants to bring a spouse from the EU, I guess is a European national, and he wants to bring his spouse from the UK. We are not dealing with the European regulations or the EU settlement applications at the moment. So the advice that we are giving is under the immigration rules, and we are not talking about European law at this point.
We will be addressing that topic in the near future.
That will be a topic that, yes, we could deal with.
But the answer is yes, you can bring your wife from Europe.
Yeah, you can bring your wife from Europe, but obviously not under the immigration rules unless your wife, if your wife is European or if you are European.
Yep.
if it makes sense. All right, okay, so we were talking about self-employment. We were talking about people who are self-employed and the requirements that they need to meet. They have to show the last full financial year or the average of the last 2 financial years, and they need to provide a lot of evidence in support of their applications. Now, as you know, we've got many of our clients who are paid in cash or are paying themselves cash. We've got the taxi drivers, for example, but we've got also many other people in this case. They can't always justify their earning in their bank accounts because they are getting cash. So is it possible for them? Can they still make an application?
Yes, they can. There is an exception within the rules where if somebody's getting cash in hand, yes, they can make an application, but I will strongly advise that they should try putting money into their account. I mean, if there's a gap, say for a couple of months, they've not put anything, that's fine. But I will still strongly recommend that they deposit the money into their account. But yes, they can make an application.
Okay, that's very good. Okay, we talked about savings. So we've already seen about being employed, being self-employed, and some people sometimes have got savings. Explain to us, with regards to the saving, what is the zero, in fact, because normally the normal zero in an account is zero. But in immigration law, the zero is no longer zero. Mm-hmm. So what is the amount of money? Which amount of money is the minimum?
16,000.
Okay, so anything above 16,000 can be taken into consideration.
Into consideration, that's correct.
So, for example, if someone has £8,000 savings, is it going to make a difference in his application?
No.
Absolutely not.
No.
That's what it's sometimes difficult for people to understand, that it will make absolutely no difference. Whether or not you've got 10,000, 8,000, it doesn't. Now, if someone has 20,000 savings, how will we calculate that?
I mean, again, we've got to look at the shortfall.
Yes.
So, say, for example, as I said in my previous response, that if there's a shortfall of £1,000, you times that by 2.5, and then you add the base on it, which is 16,000. You need to have that amount to meet the shortfall. So 16,000 plus the shortfall, you times it by 2.5, whatever that is, you add them up, that will make up the shortfall.
Yes. So, for example, if you've got £20,000 in your savings account, you need to take away out of those £20,000 16,000.
Yeah, that's zero.
You are left with 4,000 that you divide by 2.5. And why do you divide
whatever the
by
shortfall is, you divide it by whatever the shortfall is.
2.5 is the length of your visa. It's 2.5 years. So you divide by 2.5 and you end up with 1,600 that you can add to your income.
That's correct.
Actually.
That's correct, yeah.
Okay. So if anyone is not has not understood, please do not hesitate to ask.
I mean, I would say something, Severine, because, and I've said this to many clients, that it's worth having a consultation with an immigration practitioner, because if you look at it, the Home Office fee is about 2,700 approximately, from where the health surcharge is always returned to you if the application is refused, but you won't get 1,400 or 500, whatever it is, back. So it's very important that you go to someone and go through the paperwork and make sure that you meet the requirements. Otherwise, there's a high risk that you will lose the money.
Yes, that's correct. Okay, just to reply to some comments on Facebook, I've got IB Rahim. Dear IB Rahim, we are not dealing with children at the moment. We are dealing with spouse visas. This is not the topic. So next time we may deal with that. Mohammed Fayez, again, we are dealing with application outside the UK. We are not dealing with extension application. Okay? Okay, let's carry on. So, there are some non-employment income that can be taken into consideration, but as they are more complex, we are not going to discuss them tonight. I think that's for another topic. And also, we would advise, and I'm sure Brother Amjad will agree with me, that it would be easier for them to go and consult a lawyer.
Absolutely, very complicated. Very complicated.
It's very complicated, and sometimes as lawyers we turn into accountants because we have all those paperwork around us that we have to try to make sense of.
That's correct.
Okay, now, so we've seen for people who were able to meet the immigration requirement, but there are some people who can't. There are some people who are disabled, they can't work. people who are carers of their elderly parents or grandparents. And again, they cannot be expected to work. Is there something that we can do for them?
Yes.
Can they still be allowed to marry and bring someone into the UK?
Yes, they can. If you can't meet the 18,600 threshold, then you fall within the exemption. For the exemption, you need to be receiving certain benefits like carers allowance, PIP, employment. Where there's a list of benefits that you need to be earning to qualify for the exemption. But again, if you are going, which is called the adequate maintenance requirement, to fall under the adequate maintenance requirements, again, there is some rules that you need to follow. So that's the threshold of DWP, a person on income support, what his income is. So there's a different criteria that needs to apply. Again, again, you need to go sit down and go do the calculation before you could meet the adequate maintenance. But yes, the response is yes, you can apply if you can't meet the financial requirement, as long as you come within the adequate maintenance requirement.
Yes. So for our listeners, if you want to bring your husband or wife from abroad and you go and see a lawyer, you need to bring with you your bank statements. It's not because the lawyer wants to know how much is there. It's not because the lawyer wants to know if you've got savings or not, or if you are paying for Netflix. It's just because it's necessary for us to do our job properly.
Yes.
So please, when you go and seek legal advice, please take your bank statement with you, everything, so that we can have a look.
As I said, Severin, if somebody has a consultation, and what we'll do is we'll determine which route fits their circumstances. So if they meet the financial requirement, we say yes. I did a case where the sponsor was receiving carers allowance. She never mentioned it to me. So when I went to the bank statement, I said, what is this? And she said, I'm a carer. I said, if you're a carer, you don't need to meet the financial requirement. So then my advice totally changed because the facts were different. So it's very important at the outset, you go and have a consultation, take all your paperwork. If there's any paperwork missing, we will tell them to bring the paperwork so we could look into it. And then we could determine which route fits their circumstances.
That's very good. Oh, we've got a few people watching us from Pakistan, so we're going to say hello to our listeners in Pakistan. And to my surprise, we even got someone from North Africa. So, good evening, Pakistan, good evening, North Africa, and the rest of the world. If we've got anyone listening to that, you see, we are very famous now.
Immigration is a famous topic, isn't it?
Yes, exactly. Yeah. Okay, so now we've done the financial requirement. There is another requirement to meet, which is the accommodation requirement. So, what is the accommodation requirement?
Okay. As I said, accommodation is a must requirement which you need to meet. A lot of people are refused on accommodation. So what the sponsor needs to show that when his wife or her husband comes to the UK, there is sufficient accommodation. Now, the requirement is that it needs to be exclusively occupied by the sponsor, and it shouldn't be statutorily overcrowded. So normally what we recommend to the sponsor is that get a survey done from an independent surveyor, where he gives his professional opinion that if somebody comes and resides in that property, it won't be statutorily overcrowded. So there are two elements. So that element will be dealt by a surveyor's report. Now, the majority of cases I have done, and I think you'll probably agree with me, that majority of them live with extended family members. So on that basis, I think we'll probably just need a supporting letter from your uncle, aunt or parent saying that they're giving you permission to stay there, land registry to prove the ownership of the property, and then a survey report will be in addition a supporting document to show that it won't be statutorily overcrowded. So yes, the partner in the UK needs to show that he's got sufficient accommodation and it is exclusively occupied by him, and it will be available for the applicant when the applicant enters the UK.
Yes, but when we say occupied by him, it can be a room. Do you agree with me?
Yes, it can be a room. Yes,
it can
that's
be
correct.
a room.
Yeah.
So just to give you some examples, I think we checked that yesterday. How many people generally would be allowed in a 2-bedroom accommodation?
If they're under 10, they class as 0.5. If it's over 10, then class as 1. So in 2 rooms, 4 people.
Yes.
Which is according to the immigration requirement, yeah.
And we can use the sitting room or the dining room
as a bedroom.
As a bedroom.
Yes, for immigration purposes.
That's
correct.
So the couple can live with family. So we've already talked about how we can prove that accommodation is not overcrowded. Okay, now there is the famous or infamous English test.
Mm-hmm.
So which English test do you need?
A1 English test for entry clearance from abroad. As I think you covered it in your introduction, where people find it very difficult to meet English requirements, especially clients who live in Afghanistan, because according to their culture, they don't educate their children, so they struggle the most, which I've seen from my experience. So yes, English A1 is required for them to make a valid entry clearance application.
Yes. And what about if there's no center to learn English in the country? For example, in the Democratic Republic of Congo, there is no center.
Mm-hmm.
Or in Libya, actually, I believe.
Unfortunately, they'll have to travel to the neighbouring country. You may argue that I won't be able to travel, but I'll give you an example. If the embassy or High Commission is not functioning in a country, then you have to go and submit an application to the neighbouring country. They'll say, if you could go and submit an application in a neighbouring country, why can't you go and do the English test in a neighbouring country? So it may be a bit harsh, but they have to go to the neighbouring country to do the English test.
Yes, or we need to show exceptional circumstances. For example, countries being at war, like Syria at the moment.
That's exception.
Yeah,
that's exception. I mean, unless you could argue that, yeah, that's correct.
Now, I came across recently, and you did come across also, people who were disabled. They had learning difficulties, or they were deaf. What's happening for those people?
I mean, there is a provision there which supports them. If someone certainly has medical issues, they'll have to provide evidence, and that evidence needs to be provided to the entry clearance officer, and the entry clearance officer will look into it and then make a decision. If they accept it, then they'll grant it. If not, then they'll say that we don't consider this evidence as credible, so it'll be refused. But yes, there is something in the provision where you could benefit from.
That's very good. Okay, now we've told you everything about the requirements, how to meet the requirement of the immigration rules. Now we're going to talk a little bit about the process. How do we submit an application, for example?
Application process, online application. Before you used to do a paper application and online application. Recently they've changed it. Everything is done online now. You book your appointments from here, you make your payments, and you do everything online. So everything is online from today.
Yes.
If you're going to make an application.
And is there an NHS fee to be paid?
Yes, there is definitely an NHS fee to pay. It used to be, if I'm correct, £600, and they've increased it to £1,200.
So give us an idea. How much does it cost to bring a husband or a wife from abroad? So just that people who are looking to get married know that they have to save money, not only for the mortgage, but to bring their spouse into the UK.
I think if you calculate both of them together, it's about £2,750, if I'm correct. And if you want to have the premium service, then there's another £550 on top. So in essence, it will be about 3,200 something if you want the premium service, but generally it's about 2,700 something.
Yes, because
that's excluding the lawyer's fee.
Of course. The Home Office is very clever at making money, and because they know that, people want their spouses very quickly and they want visa to be decided very quickly. So they've got a service that Brother Amjad is mentioning, which is the premium service, but you have to pay for it.
Mm-hmm.
They are making a lot of money from people again. So we are looking at £3,000. And if you apply for an extension, it's another £3,000.
Yeah. I mean, I'd like to add here, Severine, I think you'll probably agree with me that whenever I advise a client to make a premium application, is I look at the circumstances. For example, where I see that there's a weakness in the application. For example, somebody got married in 2015 and they are making an application in 2020, it's more than likely, if they don't have sufficient evidence, that it will be refused on the relationship requirement. So I would strongly advise them not to go on the premium application, because it's more than likely that they will refuse it on the relationship. Compared to if somebody has been recently married, say about 6 months ago, then I will encourage them to go on the premium application, because I don't see any grounds for them refusing it. However, there's no guarantee that they will decide an application within 2 or 3 weeks.
Yes, they are very naughty. We know that. They take your money, but they don't decide it within the 3 weeks period that they are supposed to decide.
And on top of that, if somebody has got 2 jobs, I would still strongly recommend that they don't go on the premium service. Why? Because they are definitely going to interview about the employment, because when they think that there are two employments, they always believe that there's one of them is not a genuine employment. So they will definitely conduct an interview. So on that basis, paying the fast track, I don't think will bring any benefit to the application.
Okay, so now we've submitted our application online. We've paid for our NHS fee online. We need now to book an appointment online again to go and register the biometrics in the country of origin. Is it possible to book a biometric appointment without paying the application first?
No. You have to pay. I mean, to make a valid application, a valid entry clearance application, you have to make a payment. Otherwise, it won't be a valid application. And wherever you're going to go and do your biometrics, there's a fee for that centre as well.
And is it possible to book a biometric appointment in another country? So, for example, if I live in Afghanistan, can I book my appointment in India?
Yes, you can. But again, you've got to be mindful that you need to have a visa to go to that country. That I had so many Afghani clients who submitted their applications in India because they believe that the Indian High Commission makes a speedy decision compared to the Pakistan High Commission. So, yes, you can make an application in a neighbouring country.
Okay, so if the applicant misses the biometric appointment, is it possible to rebook the appointment?
No, Severine, this is... I would strongly recommend that they make sure that they attend the biometric appointment. Yes, you can. The answer is yes. But again, it depends on the provider.
Yes.
If I can remember, when we used to on the old system, you had to rebook within 5 working days, clear 5 working days. If you failed it, what you have to do is then you have to apply for a refund. The refund will come back within 28 days. And then if you want to make a fresh application again, you have to pay the fee all over again. So I strongly recommend that you please do look at the time frame and make sure you can attend. But if you can't attend, yes, there is a provision in the rules where you can apply for a refund, but it's a time-consuming and stressful process.
Okay, now I've got another question. A few years ago, a few months ago, should I say, I had a client from Bangladesh who got married in Bangladesh, and she was deeply in love with her husband. But the parents had agreed that as part of the dowry, some fields were given to her, some land was given to her as part of the dowry. Mm-hmm. Then the father-in-law changed his mind. So the father of the bride also changed his mind, but he had already paid for the application, for the visa application. So if you change your mind, once the application has been submitted, can you withdraw it and get a refund?
Well, again, it depends at what process the application is at. I mean, once you've submitted the application, and I think before they've made a decision, you can always withdraw the application. There is a provision involved there. But if they've made a decision, then unfortunately there's no refund if they made a decision.
Yes, and also if the biometrics have been submitted, I think it's more difficult.
It's difficult because obviously you've gone through the process.
Yes. Now, the other question, and this is a burning issue again, because we've got so much problem with our clients, as you know, with the submission of the supporting documents.
Oh, don't ask.
This is a very, very difficult. It's not a legal problem. It's a practical problem.
Yes.
But we've encountered so
many
much
problems.
Yes.
I mean, we were dealing with a problem today.
Yes.
From Iraq.
Yes.
Again, you know, these centres are there just to facilitate, to scan the documents. They're not decision makers. Sometimes they come across as they are decision makers, and I get really frustrated because there's nothing in the rules saying that they can ask these sort of questions. So again, as you know, before we used to send all the support documents to Sheffield. Now they're designated centres where the sponsor has to take the documents, get them scanned, and then give them back to them. Again, the burden is on the sponsor to take the documents. Again, there's a charge for them. Okay, yes. You have to pay for the service. So whenever you're going to ask for something, you'll have to pay for it.
Can they submit the documents abroad themselves?
Yes, they can. They can upload them, or they can get the documents uploaded at the centre. But I strongly recommend they do them in the UK by the sponsor. It's more efficient and more better.
It's easier.
Easier.
Okay, just to remind our listeners, we are no longer sending your documents to Sheffield. It is no longer the case. And I think it stopped in July 2019, if I'm correct. Yes, if I'm correct.
Yeah.
So the documents are no longer going to Sheffield. Anyone who makes application now has got 3 possibilities. Or you upload your documents yourself, and be ready because they could be showing that they've been uploaded on your computer, but when your wife or husband arrives in wherever, they will say they can't find them for some reason. The second option is for your partner to have the document scanned in Pakistan. At the centre, or for you to walk to the centre in the UK. There are several centres in the UK to have your documents scanned.
I would say something, Sev, that the stress we went to today in the morning, our Iraqi client, I would strongly recommend that they have their documents scanned in the UK.
Yes.
Because you have a remedy here. There, you're over the phone, talking, he was getting frustrated, emailing things forward. It's very stressful.
Also, most applications now are done on Gov UK, online on Gov UK. They are no longer done on Visa for UK. This, again, has created so many problems.
That's right.
So all applications are done on
And you're dealing with one problem, aren't you?
Yes. Yes. How long does it take for the application to be decided? You would say in general?
3 months. You'll get to within 3 months. But again, sometimes it takes longer than that. Say, for example, you have 2 employments and they call you for an interview, or they were able to interview the employer, but they were not able to interview the employee. So in that case, it could take longer than that. I mean, what happens is that there's maybe somebody else who does the interview, then he passes it back onto the caseworker. So that again is time consuming. But generally speaking, you should be getting a decision within 3 months.
And if you don't get a decision after 3 months or 4 months or 6 months, is there a remedy? Is there anything you can do?
Well, generally speaking, I would get the MP involved. I mean, obviously, I've sent emails and with no luck. If you get your member of parliament involved, ask them to send an email. They will definitely get a response.
Yes, or otherwise you can start litigation if you're very enthusiastic.
And that's, again, cost implication. I don't think the clients want to pay.
How do you know that the application has been decided?
No, good question. We will never find out. It will be the applicant they will contact directly via an email or by a telephone. So I strongly recommend to clients that they have their phones, all of it charged and on, and keep a lookout for a call, or their emails. I had a case last week, a family member, he said, I've not received any response. I said, well, you should be getting a decision because they've conducted the interview. And then he said, we've got a problem. I said, what happened? He said, well, the number we gave, you misplaced the chip. I said, in that case, what I suggest you do is that you go to the centre and ask them. They may have made a contact. Luckily, they went to the centre. They said, your passport is waiting. And the visa was granted. So it's very important that you keep an eye on your emails and you keep that chip live, active all the time.
Just to remind our listeners, your lawyer will know the law, will know the requirement of the immigration rules, and will know to a certain extent the process. But we are not working for the Home Office, we are not working for the entry clearance officers, and therefore sometimes we don't know how they deal with certain things.
Yes, that's correct.
Yeah. Unfortunately, some applications are refused. Is there a right of appeal against a negative decision?
Yes, there is a right of appeal.
And generally, how long does the appeal take?
I mean, it depends what sort of appeal you would like to lodge to the tribunal. You have a full right of appeal. You could have a paper hearing or you could have a full hearing. And that what defines that there's a separate fee for each appeal. So if you want a paper hearing, it's £80 court fee. If you want an oral hearing, it's £140 court fee.
Okay, and once, how long are you granted the initial grant of visa?
28 days. So initial grant is 28 days that you have to travel within 28 days.
Yes, if you don't travel within 28 days.
Unfortunately, then you have to make another application. And the danger is that they'd probably look at it like a fresh application. They could refuse it under some different grounds. So it's very important that you travel within 28 days.
Thank you very much for listening to the Immigration Hour. This is the end of our show. We hope that you've enjoyed your show. We will be coming back next month with another topic. Thank you very much for listening. Goodbye.
You're listening to Salaam Radio, and it's now time for Isha Azan. This Azan is sponsored by UK